If you have been scrolling through social media lately and seen alarming posts claiming that the United States government is now blocking immigrant visas because of something called the public charge rule, you are probably feeling a mix of confusion and fear right now. Maybe you are in the middle of your green card application, or perhaps you are sponsoring a family member, and now you are wondering if everything you have worked so hard for is about to fall apart. I understand that feeling completely, and I want you to take a deep breath right now because I am going to walk you through exactly what is happening, what this policy actually means, and most importantly, whether or not you need to be worried. My name is Umar, and this is Real Guide Updates, your trusted source for fact-based immigration news without the panic, without the rumors, and without the speculation that floods social media every time there is a policy change. My goal today is simple. I want to replace your fear with facts, your confusion with clarity, and your anxiety with actionable understanding. So stay with me for the next several minutes, because this information could genuinely change how you approach your immigration journey. Let us start from the very beginning because I think it is important that you understand what the public charge rule actually is before we talk about any recent changes or developments. The concept of public charge is not new. It is not something that was invented in 2025 or 2026. In fact, the idea of public charge has existed in American immigration law for well over 100 years. The basic principle behind it is straightforward. The United States government wants to know that people who are immigrating to this country will be able to support themselves financially and will not become primarily dependent on government assistance programs. Now, the way this has been interpreted and enforced has changed dramatically over the decades. For many years, the public charge rule was applied fairly narrowly. It mainly looked at whether someone was likely to become primarily dependent on cash assistance programs or long-term institutionalized care at government expense. Things like using Medicaid for emergency services, or children using school lunch programs, or families receiving certain tax credits were generally not considered when making public charge determinations. However, during the first Trump administration from 2017 to 2021, there was a significant effort to expand what would be considered in a public charge determination. The idea was to look at a much broader range of government benefits and to consider whether someone had used or was likely to use these benefits when deciding whether to approve their visa or green card application. This expanded rule faced numerous legal challenges, was blocked by courts, reinstated, blocked again, and created enormous confusion for immigrants and their families. When the Biden administration came into office, they rolled back many of these expanded interpretations and returned to a narrower definition of public charge. For several years, applicants had a clearer understanding of what would and would not be held against them. But now, as we move into 2026 under the current Trump administration, we are seeing a renewed focus on the public charge rule and some significant changes in how it is being applied. So, what exactly is happening in 2026 that has everyone so worried? Let me explain this as clearly as I possibly can because there is a lot of misinformation circulating right now. The current administration has issued new guidance and, in some cases, new regulatory actions that expand the scope of the public charge determination once again. This means that when consular officers at U.S. embassies and consulates abroad are reviewing immigrant visa applications, they are now looking more carefully at an applicant's financial situation, their likelihood of using public benefits, and their overall ability to support themselves without government assistance. The phrase you may have seen circulating online that immigrant visas are being halted is not entirely accurate, but it is not entirely false either. What is happening is that more immigrant visa applications are being delayed, denied, or placed in administrative processing because of public charge concerns. This does not mean that all immigrant visas have stopped. It does not mean that every applicant is being rejected. But it does mean that a higher percentage of applicants are facing additional scrutiny, and some are receiving denials that they might not have received a year or two ago. Now, let me be very clear about something, because I think this is where a lot of the panic is coming from. The public charge rule applies specifically to certain categories of immigrants. It does not apply to everyone equally, and there are significant exemptions that many people are not aware of. Refugees and asylees are exempt from public charge determinations. If you are applying for a green card based on refugee or asylee status, the public charge rule does not apply to you. Similarly, certain special immigrant categories, victims of trafficking, applicants under the Violence Against Women Act, and several other protected groups are also exempt from public charge considerations. For family-sponsored immigrants and employment-based immigrants, the public charge rule does apply, but it is applied in the context of the totality of circumstances. This means that a consular officer or USCIS adjudicator is supposed to look at the whole picture of your situation, not just one single factor. They are supposed to consider your age, your health, your education, your skills, your employment history, your financial resources, and whether you have an adequate affidavit of support from your petitioner. Speaking of the affidavit of support, this is a critical document that many applicants do not fully understand. When a U.S. citizen or permanent resident sponsors a family member for a green card, they are required to sign an affidavit of support on Form I-864. This is a legally binding contract in which the sponsor agrees to financially support the immigrant and to reimburse the government if the immigrant uses certain public benefits. The purpose of this document is specifically to address public charge concerns. If you have a properly completed affidavit of support from a qualified sponsor who meets the income requirements, this is supposed to weigh heavily in your favor during the public charge analysis. However, what we are seeing in 2026 is that consular officers are looking more closely at the credibility and sustainability of these affidavits of support. They are asking more questions about the sponsor's employment stability, their financial history, and whether the income claimed on the affidavit is likely to continue. In some cases, officers are requesting additional documentation such as tax transcripts, bank statements, employment verification letters, and other financial evidence that was not always required before. This is causing delays because applicants may not have anticipated these additional documentation requests. It is causing denials in cases where the officer determines that the affidavit of support is insufficient or where the applicant's own financial situation raises concerns. And it is causing a lot of fear because the process feels more unpredictable than it did in previous years. Let me address some of the specific rumors and misconceptions that I have seen circulating online because I think it is important to separate fact from fiction. First, I have seen claims that using any government benefit at any time will automatically result in a visa denial. This is not accurate. The public charge determination is supposed to be a forward-looking analysis. It is supposed to consider whether someone is likely to become a public charge in the future, not simply whether they have ever used any benefit in the past. While past use of certain benefits can be considered, it is not an automatic disqualification. The officer is supposed to look at why the benefit was used, for how long, and what the applicant's current and future circumstances look like. Second, I have seen claims that children's use of school programs, emergency Medicaid, or certain nutrition programs will count against the parent's immigration application. Under the current framework, the use of non-cash benefits by children is generally not supposed to be weighted heavily in the public charge determination for the parent. However, I must be honest with you that there is some ambiguity in how different officers are interpreting the guidance, and this is one of the areas where we are seeing inconsistency. Third, I have seen claims that employment-based visa holders are being denied green cards at high rates because of public charge concerns. While it is true that employment-based applicants are subject to public charge review, these applicants typically have strong factors in their favor, including employment offers, higher income levels, and employer sponsorship. The denial rates for employment-based applicants on public charge grounds remain relatively low compared to other categories, although they have increased from previous years. Fourth, and this is perhaps the most important misconception to address, I have seen claims that there is nothing you can do if you are facing a public charge concern. This is absolutely not true. There are several steps that applicants can take to strengthen their case and address public charge issues. If you are an applicant who is concerned about public charge, the first thing you should do is ensure that your affidavit of support is as strong as possible. This means that your sponsor should meet the income requirements, which are typically at least 125% of the federal poverty guidelines for your household size. If your primary sponsor does not meet the income requirements on their own, you can add a joint sponsor who does. The joint sponsor does not have to be related to you, but they do have to be a U.S. citizen or permanent resident who is willing to take on the legal obligation. The second thing you should do is gather comprehensive financial documentation. This includes recent tax returns, W-2 forms, pay stubs, bank statements, property ownership documents, and anything else that demonstrates financial stability. The more evidence you can provide that shows you and your sponsor are financially stable, the stronger your case will be. The third thing you should do is be prepared to explain any past use of public benefits in context. If you have used benefits in the past, be ready to explain the circumstances. Was it a temporary situation due to job loss or medical emergency? Have your circumstances improved since then? What steps have you taken to become financially stable? Context matters in public charge determinations, and providing a clear explanation can help the officer understand your situation. The fourth thing you should consider is whether you have any positive factors that can offset concerns. These include having a job offer or current employment, having significant savings or assets, having health insurance, having a higher level of education or skills that make you employable, and having family support beyond just the affidavit of support. Now, let me talk about what is actually happening at U.S. embassies and consulates, because I think it is important for you to understand the practical reality on the ground. We are seeing reports from multiple embassies that immigrant visa interviews are including more detailed questioning about financial matters. Officers are asking applicants about their work history, their skills, their plans for employment in the United States, and their understanding of the affidavit of support. They are asking sponsors detailed questions about their income, their employment stability, and their ability to support the immigrant. We are also seeing an increase in requests for additional evidence after interviews. This means that even if your interview seems to go well, you may receive a letter asking for additional financial documentation before a final decision is made. This is causing delays of weeks or even months in some cases. We are seeing some cases where applications are being denied under Section 212A and 4 of the Immigration and Nationality Act, which is the public charge ground of inadmissibility. When an application is denied on public charge grounds, the applicant does have options. They can provide additional evidence to overcome the finding, they can find a stronger sponsor, or in some cases, they can reapply with a more complete application. I want to be very clear that while denial rates have increased, the majority of immigrant visa applications are still being approved. The situation is more challenging than it was a few years ago, but it is not impossible. Thousands of immigrant visas are still being issued every day. The key is to be prepared, to have strong documentation, and to approach your interview with confidence and clarity. For those of you who are currently in the United States on non-immigrant visas and are worried about how this might affect you, let me provide some clarity. The public charge rule primarily affects applications for immigrant visas and adjustment of status to permanent resident. If you are here on a student visa, a work visa, or a tourist visa, the public charge rule does not directly affect your current status. However, If you are planning to apply for a green card in the future, you should be aware of these considerations and start preparing now. If you are a green card holder who is worried about how using public benefits might affect your citizenship application, the rules are somewhat different. While USCIS does look at good moral character for naturalization, the public charge ground of inadmissibility generally does not apply to naturalization applications. However, if you obtained your green card and later information comes to light that you were inadmissible at the time of admission, that could theoretically create complications. This is a complex area of law, and if you have specific concerns, I would encourage you to consult with a qualified immigration attorney. Let me also address what this means for people who are just starting the immigration process. If you are a U.S. citizen who is thinking about sponsoring a family member, or if you are someone who is hoping to be sponsored, you should not let these changes discourage you from pursuing legal immigration. The process may be more rigorous than it was a few years ago, but the system is still functioning and applications are still being approved. What you should do is approach the process with careful preparation. Start gathering financial documents early. Make sure your sponsor understands their obligations under the Affidavit of Support. Consider consulting with an immigration attorney if you have any factors in your case that might raise concerns. Being proactive and prepared is the best way to navigate the current environment successfully. I also want to take a moment to remind you that immigration policy in the United States does not change overnight without warning. Major changes typically require regulatory processes that include public notice and comment periods. They require implementation guidance to be issued to officers, and they are subject to legal challenges that can affect their enforcement. While the current administration has prioritized stricter enforcement of public charge, the basic framework of immigration law remains in place. The sources I encourage you to check for accurate information include USCIS.gov, which is the official website of U.S. Citizenship and Immigration Services. You should also check the State Department's website at state.gov, particularly the Bureau of Consular Affairs section for information about visa processing at embassies and consulates. For changes in immigration law, congress.gov is the authoritative source for actual legislation. And the Federal Register is where you can find official regulatory actions and their effective dates. Please do not rely solely on social media posts, YouTube videos, or even news articles for critical information about your own case. Use these sources, including this channel, as a starting point to understand the landscape, but always verify specific information through official sources or through consultation with a qualified professional. As we wrap up today, I want to leave you with a sense of perspective. Immigration policy goes through cycles. Different administrations have different priorities. Rules are tightened, then loosened, then tightened again. Through all of these changes, millions of people continue to successfully navigate the immigration system and achieve their dreams of living in the United States. The public charge rule is one factor among many in the immigration process. It is not an insurmountable barrier, and for most well-prepared applicants with solid sponsorship and documentation, it should not prevent approval. What matters most is that you stay informed, stay prepared, and do not let fear drive you to make hasty decisions. If you are in the middle of an immigration process, continue to move forward methodically. If you are planning to start a process, take the time to prepare properly. And if you receive a denial or a request for additional evidence, remember that these are not the end of the road. There are options and remedies available. If you found this information helpful, I would genuinely appreciate it if you would subscribe to Real Guide updates and turn on your notifications so that you do not miss future updates on immigration policy changes. The situation is evolving, and I am committed to bringing you accurate, calm, factual analysis as things develop. If you know someone who is worried about the public charge rule, who is in the middle of their immigrant visa process, or who has been confused by the alarming headlines on social media, please share this video with them. Accurate information is the best antidote to fear, and you might help someone avoid unnecessary anxiety or poor decisions. I also invite you to leave your questions in the comments below. While I am not able to provide individual legal advice, I do read the comments and try to address common questions in future videos. Your questions help me understand what you are most concerned about, and they help me create content that serves your needs. Thank you for spending this time with me today. Thank you for trusting Real Guide Updates to bring you the facts. And thank you for being part of this community of people who want to understand immigration policy through a lens of clarity rather than fear. I will see you in the next video. Stay informed, stay calm, and take care of yourself and your families.